Good morning, Colorado. This is the Colorado Oil and Gas Conservation Commission. It is June 15th. This is our weekly meeting. We have a short agenda ahead of us. Before we get into the agenda, we will recognize our existence with a roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez,
Here.
Commissioner McGowan, Commissioner Mesner,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 3 out of 5 commissioners present.
Thank you. And Commissioner McGowan is excused from the meeting today. She is on leave. And so we do have a quorum before us. We have a few matters on our agenda. We are not doing public comment this morning, and that's because we have a special public comment evening feature tonight at 6 p.m. and we have 2 individuals signed up for that public comment. We do have a consent agenda with 2 hearing officer recommendations under Rule 505. Are there any questions with regard to consent agenda? Seeing none, do we have a motion to approve consent agenda?
So moved. Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Consent agenda carries forward as approved. The second matter on our agenda is a update from staff on Form 3 and the financial assurance plans. Ms. Larson, are you providing that update, or are we going to hear from Deputy Director Scott Cuthbertson?
Yes, and I was just going to let you know Mr. Cuthbertson was joining. We had a little technical glitch, but he is here.
Good morning, Scott. Good to see you.
Good morning, commissioners. Thank you. I'm on your agenda today to make you aware of a development that has had a pretty significant impact on our implementation of the financial assurance rules that were made effective April 30th, 2022. As you know, in order to meet our goals of making information widely available as soon as the information is in and to maximize the efficiency of the data review process, we communicate with our administrative stakeholders through the use of digital forms. Doing so eliminates duplicate entry of data, provides the information in a readily reviewable format, and makes the information immediately accessible to any interested party. The downside is that the development of new processes or forms like that required to implement new rules requires a robust understanding of the complex system used to manage the forms. While the logic of the financial assurance rules is fairly straightforward, implementing the various options of Rule 702 is quite complex from a data management standpoint. Rule 702, as you know, requires operators to submit an initial financial assurance plan by July 1st of 2022 if that operator has 50 or more wells, October 1st if they have more than 10 but less than 50, and December 31st if they have 10 or fewer wells. Sorting out the technical implementation of Rule 702 has been an extensive process. Staff has had numerous internal and external conversations to ensure the correct implementation of the new rules. But we recognize it's critical to get the technical implementation correct in order to ensure financial assurance processes are clear to all the stakeholders, including those processes around the intake of information, the associated calculations, and how staff will review that information and process it. We designed a process that would minimize the ultimate effort required by operators to prepare plans, as well as the associated effort by COGCC staff to process those plans. While that design approach requires more time on the front end, it significantly reduces the overall time required for operators to submit plans and for staff to review them. While it was ambitious, we believed we had an effective plan that would result in the development of the forms necessary to implement the financial assurance rules by early June. The aggressive implementation schedule and commitment to a more elegant solution meant that success depended on no serious disruptions. 2 weeks ago, our lead developer, who has 18 years experience developing applications for COGCC, had to take emergency leave and will be unavailable for the foreseeable future. As I mentioned earlier, our COGCC database and systems are a robust, complex solution that ingests, manages, and displays enormous amounts of information in real time. And you can't develop in that environment without a significant amount of training. Becoming an effective developer in that environment, like I said, requires months of training and orientation. And without getting too much into the weeds, it's going to take us several weeks for one of our other developers to get up to speed on what I would represent as a 90% complete product. It will likely then take a couple more weeks for that developer to finish the remaining 10% of the product. Factoring in the already scheduled summer leave for that developer, we will not be able to complete the forms required for operators to comply with the financial assurance rules until mid-August. This means the operators with a July 1st, 2022 deadline to submit their initial financial assurance plan will not be able to comply with that directive. This affects 63 of the 394 operators that would be required to submit an initial plan pursuant to Rule 702 based on the data in the database today. Just as an aside, there are 82 operators that would be required to submit a plan by October 1st, and there are 249 operators that would be required to submit a plan by December 31st. Of those 249 operators, 114 have only one well. That's just sort of contextual background. While it's entirely moot at this point, I do want to communicate that had we not lost our lead developer, I truly believe we would have met our goal of having an implementation in place by early June. I do apologize that this is where we are, but I wanted to update the commission regarding our revised implementation schedule. So that's what I had to report today, Chair.
Thank you, Mr. Cuthbertson, for the report. Given this development, I might want to call on AAG Davenport for his thoughts about what the potential workaround is, given that the deadlines that are not meetable are contained within our rules, and obviously we don't have time for a rulemaking emergency or otherwise between now and then. AAG Davenport.
Thank you, Mr. Chair. Excuse me. One of the things that we have considered, that I've considered, is employing the director's prosecutorial discretion to make decisions about whether or not to enforce that July 1 deadline. As commissioners know, the director does have substantial discretion in whether and how to prosecute or assert alleged violations of the rules. And I do think in this case, attempting to compel compliance with the July 1 deadline would be difficult and presents at least two legal concerns. The first is that there is a generally accepted principle from courts around the country that it would be contrary to the APA and is contrary to the APA to enforce a rule where compliance is impossible. The second is I'm also aware of case law finding that non-compliance is excused where the regulated entity could not comply for various reasons. To me, this situation fits that, or could fit that. And so something this agency has used in the past is a notice to operators. It's kind of a statewide heads up, for lack of a better description, or it can also be a notice of a statewide requirement. In this case, I think given the director's prosecutorial discretion or acting directors, as well as the legal principles I've discussed, I think it would be appropriate and legally supportable to issue a notice to operators statewide that states that the director will not enforce the July 1, 2022 deadline for financial assurance plans. I believe that applies to under Rule 702 to operators with 50 or more wells. and instead provide some breathing room for the staff to finalize the form and to get it out to operators and to use it, in which case that notice to operators could provide, for example, that while the director would not enforce that July 1 deadline, that it would give operators a certain amount of time once that form is released to get their financial assurance plans in, and that as long as those financial assurance plans were in by a specific date, we could also administratively declare those to have been submitted by July 1.
Interim Director Cuthbertson, does that work with your staff? And if so, what's the deadline that you would think is appropriate if you're going to have the form developed by, mid-August?
Yes, I do completely support that approach. I mean, and I appreciate that insight from AG Davenport. I have high confidence that we will have this implementation done by mid-August, but I also had really high confidence that we would have it done by early June, barring unforeseen circumstances. And having failed once, I'm really hesitant to fail a second time at this. And so while I'm confident we'll be ready by August 15th, I guess to just keep us from being here again, I would suggest maybe an additional 30-day delay for the July 1 compliance date. And that it's important to point out too, I believe the only compliance that's affected by this development is that associated with those operators of 50 or more wells that have a July 1 deadline. I think all the other aspects of the rules are unaffected by this development. And so really all that's affected is the July 1 deadline for those 50 or more well operators. And I would suggest that our NTO just provide an allowance to have until September 15th, just to make sure that we don't have to start this again.
Yeah, no, that makes sense to me. And so the other tranches of operators that have the October and then the later deadlines would just, they'll be ready to go because the form will be ready. Is that accurate?
Yes, and at the risk of getting into the weeds, but also for the sake of all those who I know are listening and continue to be anxious about complying, because that's their goals. They have corporate goals to comply, and they are good administrative stakeholders. We have already looked at, when we had our lead developer, he's such a robust asset that we didn't worry about making that what we call the Form 3 that we're going to accept the plans through complicated, because he could handle it. Now we are all hands on deck, and we've identified a couple of simplifications that we can do that will enable operators to get started with a much simpler form. One is those operators who are going to file for a number of different operator numbers to consolidate all of the operators into a single financial assurance plan. We've pulled that out of the Form 3. It'll be its own separate Form 3C that we'll be releasing really quickly so that they can get that out of the way. Also, operators with federal assurance wells, we had included that in the Form 3. We're pulling that out as well and going to do a separate simple form so that those operators with federal wells can provide us that information much more quickly before the rest of the Form 3 is done. That does two things. It allows operators to get started on giving us the information we need that impacts the calculations of Rule 702 quickly, and it simplifies the Form 3 for our developer that is being tasked with a very high bar to come in and replace our 18-year veteran developer. And they are completely competent. I have all the confidence in the world for them, but this is such a complex system. It just takes weeks of understanding how everything works to be able to develop competently. So I think that's the plan that I'm comfortable with and have a lot of confidence that we can do.
But Mr. Cuthbertson, one other sort of teeny component of this, our operators, do desire to, fully be in compliance with rules. And I would anticipate there might be some operators that might want to file something by the July deadline. It might be helpful if the notice to operators sort of specifically says, don't file anything until we get to Form 3 and only file using the Form 3. That way we can ensure that everybody's filing in a similar format under the new September 15th deadline.
I think that's good, and that's good advice. We will certainly include that.
All right, well, thank you for the update. We all recognize that, life events happen, and we're doing our best at the commission to ensure that once the correct forms are developed, they will be usable. I think this is an appropriate direction. So I give it my thumbs up. Thanks for the update. Definitely go ahead from my perspective. Happy to have you file that notice to operators. Do any other commissioners have any additional thoughts, questions, concerns about the direction that the interim director is taking here? All right, again, thanks for the update. Issue the notice. I would encourage any operator that has questions that may be listening to reach out to Mr. Cuthbertson or Ms. Larson if there are any questions, but the notice will issue forthwith.
Thank you very much for your time today.
All right. We now will move
Jeff, you're cutting out a bit. We can't hear you.
All right.
You might have just moved too far from your mic.
Docket 2112-00237, Cure McGee Comprehensive Area Plan request for stay. And I believe we are going to first hear from applicants. Commissioner Gonzalez.
Yeah, Jeff, Chair Robbins, I'm sorry. Thank you so much. I just wanted to reiterate the comment and disclosure I made, I think back in April when this originally came before us. I previously worked for Oxy Anadarko. I have worked on this project individually and in a managerial capacity with members of my team working on this project. Wanted to reiterate that if any of the parties, or I know we just have Kerr McGee today, but if Kerr McGee or any of the commissioners would like me to recuse myself, I'm glad to do so, and I want to put that offer out there. I do think I can take an impartial view in my decision-making responsibilities on this matter, but wanted to make that disclosure and daylight it for my fellow commissioners today and for the applicant.
Thank you, Commissioner Gonzalez. Ms. Jost, I think you're recognized.
Great, thank you. No concerns on our part, Commissioner Gonzalez. Chair Robbins, if we're ready, I just want to make sure everyone's in, and then I'll share my screen.
Yeah, everyone's in. Commissioner McGowan is on leave today, and so you get the three of us.
Excellent, thank you. And Mimi, thank you for bringing in the group from Kerr McGee as well. It looks like we're just missing one, Mr. Dave Hartel.
And Ms. Jost, forgive me, I've not been able to locate Mr. Hartel.
Okay, so let's see here. I believe he would be logged in under, the last name is Haertel. And would it be helpful if he raised his hand?
That would be very helpful because I don't see anyone with that name in the meeting.
Okay, excellent.
Oh,
Yeah.
okay.
Great, thank you so much. All right, I'm gonna go ahead and share my screen. Start the presentation.
And Mr. Hartel, just so you know, your Zoom login is a series of letters and numbers. If you're able to change your name, that would be helpful.
Excellent, great. Well, Chair, if it's okay, I'd like to go ahead and start. Great.
Go for it.
Excellent, thank you. Well, good morning, commissioners, commission staff, and the members of the public. My name is Jamie Jost with Jost Energy Law, and I, along with my partner, Kelsey Wieselinki, represent Kerr-McGee Oil and Gas Onshore LLP, or LP, I'm sorry, in this request to stay hearing on the Rule 314 Comprehensive Area Plan that is pending, that you will hear fully in August of this year. So I'm going to be presenting on behalf of Kerr-McGee this morning. I do have several subject matter experts with me from Kerr-McGee in case you have any specific questions over our presentation this morning. Just to start, prior to the Bronco Cap application filing in December 2021, Kerr-McGee gave very thoughtful consideration as to whether a request for stay would be necessary because there were no pending OGDPs or DSUs within the cap boundaries. But given the uncertainty about the timing of the hearing for the cap, as well as the uncertainty for potential future filings, Kerr-McGee did decide to go ahead and move forward with respect to the stay because it is allowed under Rule 314. So at this point, the stay would only be in place for approximately a month and a half, but Kerr-McGee does still deem it valuable for purposes of the cap. I do want to note that we did submit a full presentation last week. And I'm only going to hit on a few of the slides given our timing for purposes of presentation today. So if you do have any questions on the other slides, please don't hesitate to let me know. Just by way of background and familiarizing the commission with the Bronco Cap, the cap covers approximately 24,300 acres in primarily undeveloped minerals in townships 2, 3, and 4 north, ranges 62 and 63 west, located in Weld County. Weld County is the relevant local government, and there are no proximate local governments for purposes of this project. The cap proposes to develop minerals from approximately 11 oil and gas locations, and with a maximum of 209 new horizontal wells in the cap boundaries. Kerr-McGee is seeking the preferred 6-year term for the Bronco Cap and currently is not seeking preliminary siting approval and also is not seeking a variance. This stay is coming in under the allowance purely under Rule 314. Kerr-McGee has been working on the Bronco Cap for many months, with the detailed pre-application cap preparations really hitting the ground in October 2021, and those continued through December 2021 when the cap was actually filed. The Bronco Cap submission was deemed complete in April 21st. The notice of hearing for this stay, as well as the notice of hearing for the cap, I'm going to call it the substantive hearing in August, was issued on April 21st, and all of those notices were mailed out via certified mail on April 26th. Kerr-McGee is now in the formal consultation process with Weld County, CDPHE, CPW, and the BLM. And those meetings will be wrapped up by the close of the public comment period, which is June 20th, pursuant to Rule 314. They did hold the required community meeting on Monday, May 23rd, where 2 notice parties attended. There was 1 representative of the Colorado State Land Board, as well as a representative of Civitas. I'm going to go ahead and skip to slide 9. Kerr-McGee holds an approximate 53% interest in the cap lands and does have consent of Survey Enterprises, who's the surface owner as well as a mineral interest owner in the cap lands for the stay, as well as the proposed development for the cap. The cap boundary contains approximately 19,000 acres of fee minerals, 5,000 acres of state minerals, and approximately 320 acres of federal minerals. The surface ownership within the cap boundaries is made up of 1 singular fee owner, and this is the Survey Ranch, as well as the Colorado State Land Board. Kerr-McGee did successfully execute a surface use agreement with Survey Enterprises, and that agreement is recorded in Weld County, was recorded in April of 2022. Kerr-McGee has engaged in various and multiple discussions with stakeholders both prior to filing and has continued that engagement as the project progresses. Kerr-McGee has also worked with the COGC staff to schedule the necessary formal consultation meetings, as already talked about. And again, those meetings will conclude on or before June 20th, pursuant to the rule. Without diving into the granular details of the cap that will be heard in August, the submission of this cap for the comprehensive development of approximately 24,000 acres does support the use of fee surface with the consent and support of the singular landowner, the consolidation of oil and gas locations, facilities, and infrastructure, a reduction in the duration of operations, timing impacts, emissions, and surface impacts, as well as provides consistent BMPs and operational standards across each of the locations that will develop the cap. We feel that all of these are examples of meeting the purpose of Senate Bill 181, as well as Rule 314. So really simply put, Rule 314 D5 contemplates stays in this instance. This allowance of a stay in Rule 314 was a critical component for operators utilizing Rule 314 for overall comprehensive development. And today we would just ask for an order staying any final action on an OGDP or DSU that may be filed between now and the August hearing, while the staff and the director continue to conduct their review of the cap application for your determination in August. So thank you for your consideration of our presentation and our request for stay today. And like I said, I have a group of subject matter experts from Kerr-McGee who are here to help me answer any questions you may have.
Thank you for the presentation, Ms. Jost. Do commissioners have questions of the applicant? Commissioner Gonzalez?
Thanks, Chair. Thank you, Ms. Jost, for your presentation today. So I want to revisit some things that came up in April, or as part of the originally planned April hearing. There was a public comment from Hobie Minerals, a 7,000 acre mineral owner, opposing the stay. There was a protest from Verdad and a protest from Bonanza Creek. Verdad holding about 2,100 acres, but Bonanza holding about 8,800 acres of leasehold. And I'm curious, their concerns were a couple fold. One was insufficient communication and information, maybe even participation in the cap planning. And then the other was a Verdad protest about it being able to, or precluded from developing its minerals in the cap area during the time of the stay. Has there been any, I guess, is there any update from the operator in terms of communication and coordination with these other working interest owners in the cap area?
Yeah, absolutely. And thank you for the question, Commissioner. Yes, those conversations have been ongoing with Hobie, Civitas, as well as Verdad. And again, I believe those are ongoing weekly, in many instances, maybe sometimes daily, specifically for purposes of the Bonanza and Verdad protests that were filed. There was a little bit of a notice due process issue. You know, the notice was reissued for this hearing. I do believe that there were consistent communications between Kerr-McGee as well as the Civitas group and Verdad about the cap itself, as well as the stay, which I think is why you haven't seen a petition for the stay hearing today.
Yeah, and I do acknowledge that today's hearing does come unprotested. So
yes,
thank you for that update. I think that's my only initial question. Appreciate it.
You're welcome.
Any other questions of the applicant? All right, seeing no further questions, and seeing as this was, in my mind, pretty straightforward, do we have a motion?
I will move approval of the stay through, and let me clarify one thing before we do that. So Ms. Jost, in your presentation, you request 2-month stay. You know, that's give or take right around that August 5th hearing date. Are you asking for a 2-month stay, or are you asking for a stay until the August 5th hearing date?
Great question. Thank you. I mean, we would be asking for a stay until this commission makes a final determination on the cap hearing, which is currently set for August 3rd. If that gets pushed, of course, we would request that stay in place until you make your ultimate determination on the cap.
Would the operator be comfortable if we had some, you know, let's say that the cap was heard I guess until the hearing of the cap, right? If it's continued, that's a different story. But if we're hearing the cap and there's reason for this commission, of which I will not be a part of at that time, to determine that they want more information or the cap may be denied or what have you, that at that time it'd be appropriate for the applicant to request their stay for an additional term.
Yeah, I don't think there would be any issue with that, Commissioner Gonzalez, because if we're already in front of you for hearing and there's a determination that additional information is needed, we can make that request to extend the stay until, again, the additional information is able to be submitted. And then you, as the commissioners, or recognizing you won't be there, but the commissioners at the time will have the ability to hear it. We can do that.
Okay. Yeah, I think that sounds like a fair way to do it, just given that we did have some concerns in the previous iteration of this stay. Yeah, and so I'll move forward with my motion. I'm going to make a quick comment ahead of that. In the creation of this 314 rule in mission change, I made comments about the ownership threshold that I thought was appropriate for a cap and for a stay, with specific regard to I guess the rights of other co-owners in those areas, and the potential for one operator to usurp the ability to operate an area through a stay, through single operatorship, through a cap. And I suggested that it should be a pretty high threshold. Now, Kerr-McGee comes today unprotested. There were previous protests. Kerr-McGee stands at about 53% ownership there. I think that if the stay request was a little bit longer, perhaps there might be more concerns on my end in that regard. But I will say that given that we're about 6 or 7 weeks out from that August 3rd hearing, I don't think that this stay would be terribly onerous. I think it would be fair to allow Kerr-McGee to fulfill the work they've already started in this regard to get to that August 3rd hearing. And I would therefore put forward a motion that we approve Kerr-McGee's requested stay through the August 3rd hearing or any continuance thereof. And that's my motion.
Do we have a second?
Second.
There a motion and a second. Is there further discussion? Seeing no further discussion, all those in favor signify by saying aye.
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 Any opposed? Motion carries. Thank you, Ms. Joes, for the presentation.
Great, thank you. Have a wonderful day.
You as well. With that, our docket for the morning is now concluded. I believe we are to adjourn until 6 p.m. At 6 this evening, we have our monthly public comment session during the evening to allow folks to bring issues before us. I believe 2 people have signed up, so it will not be a lengthy public comment this evening, but we will adjourn now temporarily, reconvening at 6 p.m. on the same Zoom panel. AAG Davenport, Hearings Manager Larson, did I get that right?
You did indeed.
All right. See everybody at 6. I think we can begin. The webinar is being recorded. Good evening, folks. This is the Colorado Oil and Gas Commission, and this is our monthly nighttime meeting. We do this to allow for folks to speak to us outside of business hours, but we don't have too many people signed up, just 2. I would note that we have 2 people signed up, Kate Burke and Kim Sanchez, both with Boulder County. And then we had 1 written public comment from Karen Artell. Ms. Larson, I'm noting by looking at the participant panel that, okay, you raised Kate Burke. Let's recognize Ms. Burke and see if Ms. Sanchez is going to participate. I also note that David Hughes, who's one of the Boulder County attorneys, is a participant. What's your pleasure, Ms. Burke?
I think we could bring in Kim Sanchez. She may have something to add. And then David, I think, was just going to listen in. So I think we can leave him in that status.
Okay. Kim's not with us yet.
Oh, okay.
So let's just put a hold on everything. Before we get to public comment, there is a placeholder for any commissioner comments. If anybody's got anything for the good of the cause, speak up and we can kill a few minutes to allow Ms. Sanchez the opportunity to participate.
Go Avs.
Very appropriate commissioner comment. Commissioner Bogue is with us this evening. Nice to see you. Thanks for taking time out of your evening. Commissioner McGowan is still out of the office today, so she's not with us and she is excused. No problems there.
Chair, it's possible that Ms. Sanchez might be a little bit late. Now that I think about it, I wasn't sure of her schedule. So we could go ahead and get started. I was going to speak. We were going to pool our time, but I've got them kind of the bulk of the presentation here. And then if she's able to join, she can.
Yeah, and Ms. Burke, I'll give you whatever time you need. You're not stuck with 3 minutes, and I know you will be judicious with your time, and you're a good lawyer and you know when you've said enough. So we definitely look forward to hearing from you, and thanks for being with us this evening.
Thank you. So I'll go ahead and start. And then, yes, if we see Ms. Sanchez appear, then we could maybe bring her in as well. So good evening, Commissioners. Kate Burke for the Boulder County's Attorney's Office. So we pulled our time. You already know about that. We're good to go. Okay, so we are here to bring your attention to an important legal issue that urgently affects Boulder County. But beyond us, this problem undercuts the intent of SB 19-181 and affects mineral owners potentially across the state. So to lay it out for you, Extraction and Oil and Gas is preparing to drill 17 wells on Boulder County's border. From there, it will drill 4 square miles in Boulder County. That's the DSU. And in that DSU, the county owns the majority of the surface land and approximately 57% of the mineral rights. The county has mineral title opinions showing that most of its mineral rights in the DSU are either unleased or under leases that have likely expired by their terms. So if the county's right on that, it may well own more than 55% of the minerals in the DSU without leases. Extraction disputes this fact at this point. Regardless, Extraction is surging ahead to start drilling in 3 weeks on July 6th. It accelerated that schedule from its previous plan to drill in the fall. But it has not even taken the first steps to pool the county's minerals by sending a good faith offer to lease. It's also declined to meaningfully engage with us on this issue when we asked. And so in other words, Extraction is about to commit what's likely a blatant trespass or worse by drilling county minerals without either a county permission or a pooling order from the commission. So you have the authority to determine whether a forced pooling of the county's minerals is proper under the act and your rules, but Extraction is skirting that authority at this point. The commission rules appear to make room for this to happen. Rule 506A follows SB 19-181 in requiring that an operator own or control more than 45% of the minerals in the unit before applying for statutory pooling orders. That's fine. But it also suggests that an operator may apply for statutory pooling after it drills its wells, even though the logical time to prove a threshold 45% requirement is before drilling begins. Given that Extraction has to first send the county a good faith offer to lease, which it hasn't, and let 90 days elapse before a hearing, even if it wanted to, Extraction could not obtain a pooling order before it says it's starting to drill on July 6th. So the 45% threshold was added to the statute to ensure that an operator is a significant owner in a unit before it's allowed to take the drastic step of forcing an unwilling owner to give up control of its property through forced pooling. But if an operator is allowed to drill first and then try to prove its threshold eligibility later, the protections built into that requirement are virtually eliminated. Extraction may not be able to reach the threshold if the county prevails on these parties' dispute. But if it drains the county's minerals in the meantime, the damage is done. to the county's property rights, to the environment, and to the residents who will have to endure months of drilling and fracking activities. So we need the force pooling provisions to work the way they're intended under your oversight. We need time to work out our ownership dispute with extraction, and we need you, the commission, to examine whether a force pooling is appropriate in this situation. All of that before the minerals are drained, and making that happen is within your discretion. We're open to your suggestions on next steps on this, but if nothing else, we are prepared to file an emergency application to you for a pause on drilling until extraction proves its right to drill county minerals and obtains your authorization to do that. Your rules are at issue here, and your authority and mission support that relief. And I do want to be clear, this is not just a Boulder County issue. Operators should be required to prove their entitlement to access other parties' property before they do. Regardless of what happens in our particular case, we will be looking for solid long-term solutions to this confusion over the rules. So thanks for your time, and I'm available to answer questions or have a discussion on this. And we would also be happy to meet with you or your staff another time.
Okay, thank you, Ms. Burke. I would note that Ms. Sanchez is a participant and declined to be elevated, so she let you do all the talking and you didn't find. You know, I think I don't know that I have any questions. I understand the theory or the facts as that are set forth. You know, kind of like any maybe good judge, can I take it under advisement? I don't have any answers, but I'm interested in, you know, having an exploration of the issues. And so thank you for bringing that to our attention. Let me ask us a follow-up question though. Does extraction has a valid 2 and 2A relative to a location and in Weld County, is that right?
That's right. And I will, Kim just texted me. She said she did not decline to participate. So I guess that was a mistake. I don't know if maybe we want to invite her again, just in case.
Okay, we'll try again, for sure.
Yeah, this is the DSU that is, it's 4 entire sections in Boulder County right up against the county line. And then it's got a little, about 100-acre tab sticking off into Weld County. And so the well pad is in Weld County, but 93% of the DSU itself is in Boulder County.
Okay, there's your partner in crime, Ms. Sanchez. Thank you, glad to see you.
Hi there, good to see you too.
Ms. Burke presented on behalf of your community and we were just having a bit of a dialogue. If you have anything further to present, we're happy to hear from you as well, Ms. Sanchez.
Kate covered it well, thank you. I'm just available for questions if you have any.
Okay. Well, again, I think what we'll do is we'll direct this to our interim directors that are in charge of the division and, you know, have them look into it. Have you had discussions at the staff level?
We had some discussions. We talked with Director Murphy and we talked with AAG Davenport and Ms. Larson some time ago just about the rules and the idea of drilling after pooling and how that worked. And they explained kind of the commission's position, but we didn't get into the facts of this specific instance. We didn't, until very recently, we expected extraction to start drilling in several months. And so we've been half expecting to get the force pooling procedure started. And so when they let us know they were drilling imminently without even the first steps, that kind of, you know, alarmed us. And I just want to summarize, maybe it's clear, but just to summarize what, you know, I think this issue arose with the addition of the 45% threshold in combination with the ability to pool after drilling. I think those two things really highlight the conflict there. And this situation is the perfect example of that.
Does any other commissioner have questions for the panel? Commissioner Gonzalez?
Yeah, thanks, Chair. I just want to familiarize myself with the area a little bit better. I'm sorry, Ms. Burke, I don't recall if you said a pad name or well names, or if you can give me a location.
Yeah, it's the blue paintbrush pad and the blue paintbrush DSU. The sections in Boulder County are in Township 2 North, they're 13, 14, 23, and 24. The Weld County piece is, I'm not sure what section. My map's not showing me.
Okay, but 2 North generally on the
Correct.
Weld Boulder County line.
Right, exactly.
I'll find them. Thank you.
Yeah, just south of the city of Longmont.
I think there's some blue bonnet wells in there as well. Is that right, Kate? So it's
Yeah,
blue paintbrush and blue bonnet.
Well, the whole project's called Blue Paintbrush, and some of the wells are called Paintbrush, and some of the wells are called Blue Bonnet. And so together it's Blue Paintbrush, if that makes sense.
Okay, well, thank you both for appearing this evening. We will get staff to look into it a little further now that you've brought it to our attention, and we will be getting back.
Okay, thank you.
Thanks. And just to reiterate, time is sort of the essence with this if they really are to begin drilling July 6th. So we do have, concerned people in the neighborhood and residents in unincorporated Boulder County that would be impacted as well.
Understood. Thank you both.
Thank
Thank
you.
you.
Good evening.
With that, our agendized matters are concluded for the evening. That was the extent of public comment. With no further ado, I would look for a motion to adjourn.
So moved.
Second.
All those in favor of adjournment signify by saying aye.
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 Aye. Thank you very much. Good evening.